Welcome to the August 2023 edition of our HR Focus, your source for news on HR trends and federal, state, and local legislative updates. The content in this news update should not be considered legal advice. Before acting on these legislative updates, employers may need to seek the advice of an employment and labor attorney for additional guidance. Our topic of the month is updates to Form I-9 and remote document verification for E-Verify users. Effective August 1st, the new version of Form I-9 is now available for use. This version contains changes to the form and the instructions, including shortening the form to 1 page and reducing the instructions to 8 pages. Employers may begin using the new form or may continue to use the prior form dated October 19th of 2019 through October 31st of this year. However, by November 1st, only the new form dated August 1st of 2023 may be used. A revised Spanish version of the form is also available for use in Puerto Rico only. The version date can be found at the lower left corner of the form. Also, as of August 1st, employers who participate in E-Verify and are in good standing may use a video call for verification of work authorization documents rather than in-person inspection. The video inspection may only take place after the employee transmits a copy of the documents to the employer, and the employee must present the same documents during the live video interaction. If an employer offers the alternative procedure at a particular hiring site, it needs to be offered to all employees at that site. However, there is an exception. If employers want to offer the alternative procedure only for remote employees and do an in-person inspection for on-site and hybrid employees, that is also allowable. Notably, employers cannot require employees to use the alternative procedure if they don't want to, and they will need to perform an in-person examination for those who are either unable to or unwilling to participate in the remote verification process. This could arise when new employees don't have access to the necessary technology, or they may be uncomfortable transmitting sensitive personal information electronically, particularly if the employer hasn't provided a secure way for them to do so. Regarding the end of COVID-19 flexibilities, qualified employers may also use the alternative procedure to satisfy the requirements to physically examine documents by August 30th. However, they may only do so if they were enrolled in E-Verify at the time of the remote examination and they created a case for the employee, and the remote inspection was performed between March 20th of 2020 and July 31st of 2023. Employers who were not enrolled in E-Verify during the COVID-19 flexibility period cannot enroll in E-Verify now and use this alternative procedure in lieu of physical verification for those hired between March 20th of 2020 and July 31st of 2023. And they must complete physical verification by August 30th. However, they may enroll in E-Verify and be able to use the alternative method from August 1st going forward. The EEOC recently updated its Visual Disabilities in the Workplace and the Americans with Disabilities Act guidance to highlight new technologies for reasonable accommodations and to address issues related to the use of algorithmic or artificial intelligence decision-making tools. The guidance provides a series of questions and answers that discuss when an employer may ask an applicant or employee questions about a vision impairment and how to treat voluntary disclosures of such information. What types of reasonable accommodations applicants or employees with visual disabilities may need, how an employer should handle safety concerns about applicants and employees with visual disabilities, and ways for an employer to ensure that employees are not harassed because of a visual disability. The guidance explains that employers have many options for accommodating applicants and employees with visual impairments and provides options which may be applicable. The EEOC's technical guidance also includes information clarifying that employers are legally obligated to make reasonable accommodations in connection with an employer's use of software that uses algorithms or artificial intelligence as a decision-making tool. The EEOC also warns that such AI tools may intentionally or unintentionally screen out individuals with disabilities in the application process and when employees are on the job, even though such individuals may be able to do those jobs with or without reasonable accommodation. Under a final rule from the Occupational Safety and Health Administration that will take effect on January 1st of 2024, establishments with 100 or more employees in designated high-risk industries, including certain sectors of the manufacturing, transportation, and agricultural industries, will be required to submit OSHA 300 log of work-related injury and illness in Form 301 Injury and Illness Incident Reports to the agency annually of each year. Currently, employers covered by electronic submission requirements, which are establishments with 200 or more employees and smaller establishments with 20 to 249 employees in high hazard industries, are required to submit only the Form 300A, not the more detailed information on the 300 logs in Form 301. OSHA is also expanding the list of high-risk industries in which establishments with 20 or more employees must electronically submit information from their OSHA Form 300A annual summaries. OSHA intends to publish some of the data collected on its website to allow employers, employees, potential employees, employee representatives, current and potential customers, researchers, and the general public to use information about a company's workplace safety and health record to make informed decisions. OSHA believes that providing public access to the data will ultimately reduce occupational injuries and illnesses. OSHA has also released a national emphasis program focusing on the warehousing and distribution center industry in response to massive employment growth and high injury and illness and days away, restricted, and transfer rates. The National Emphasis Program is a temporary program that focuses OSHA's resources on a particular hazard in high hazard industries. This program will allow OSHA to direct resources to establishments where evidence shows employers must be more intentional in addressing the root causes of worker injuries and align their business practices with the goal to ensure worker health and safety. This program also will target certain high industry injury retail establishments, and the first 90 days following the publication of this program will be used for outreach and education. Inspection activity will begin thereafter. The program will expire 3 years after the effective date of July 13th, 2023. The program is projected to lead to an increase in inspections and the possibility of citations and penalties. Employers in these industries may want to act now during the 90-day outreach period by conducting reviews of their safety and health programs and educating their safety personnel and managers on what to do if OSHA arrives for an inspection. Effective October 1st of 2023, Connecticut's paid sick and safe leave law is amended to add Mental Health Wellness Day as a qualifying reason for paid sick leave and to extend paid safe leave coverage to eligible employees whose child is a victim of family violence or sexual assault under certain circumstances. As a refresher, Connecticut's mandatory paid sick and safe leave was adopted in 2012 and allows covered employees to earn 1 hour of paid sick leave for every 40 hours worked, up to a maximum of 40 hours per year. However, the law only applies to employers with at least 50 employees and only covers service workers who are either paid on an hourly basis or are classified as non-exempt under the Federal Fair Labor Standards Act. Covered employees fall broadly in industries such as retail, healthcare, hospitality, custodial, and food service. To determine the employee count, all employees are counted, not just the service workers. Effective August 7th of 2023, Colorado has amended the Healthy Families and Workplaces Act to include additional qualifying reasons for paid leave. In addition to the existing reasons for which leave may be used, employees may now use leave to evacuate the employee's place of residence due to inclement weather, loss of power, loss of heating, loss of water, or other unexpected occurrence or event that results in the need to evacuate the employee's residence. Colorado's anti-discrimination law has also been expanded to include marital status as a protected characteristic. This means that employers should not inquire about an applicant or employee's marital status or use that information when making employment decisions. Colorado has also created its own definition of harassment. While it closely resembles the federal definition, the state law does not require that unwelcome conduct be severe or pervasive to rise to the level of being unlawful. These changes expand the scope of the conduct that might be considered harassment and makes the state's law more protective than federal law. Employers should keep this in mind when investigating and responding to complaints. Effective September 30th of 2023, the minimum wage in Florida will increase from $11 per hour to $12 per hour. Hawaii has become the 9th state to mandate pay transparency for employers. Beginning January 1st of 2024, Hawaii employers with 50 or more employees will be required to include a pay range in job listings. The range must reasonably reflect the employer's actual expected compensation for the role. Although the primary purpose of the law is to address pay inequity, the law also cites efficiency in recruiting and interviewing as an ancillary benefit. By disclosing a pay range up front, it reasons that an employer has a better chance of receiving applications from candidates willing to work for the posted salary, thereby avoiding the time spent interviewing candidates who expect to earn more than a particular role may pay. Unlike similar laws in California, Washington, and New York, Hawaii exempts internal postings from promotions and transfers within a current employer. Also exempt are public employee positions such as collective bargaining agreements. The law also broadens Hawaii's equal pay law to prohibit pay discrimination based on any protected characteristic. The existing law applied only to sex-based pay discrimination. Effective January 1st of 2024, an employer with employees who do not regularly report to a physical workplace, such as an employee who works remotely or travels for work, must be provided with the Your Rights Under Illinois Employment Law poster and Illinois Day and Temporary Labor Services Act poster by email, or by conspicuous posting on a website or company intranet if that site is regularly used by the employer to communicate work-related information to employees and is able to be regularly accessed by all employees freely and without interference. The Illinois Victims Economic Safety and Security Act has been amended to expand the list of circumstances for which employees may take leave. Starting January 1st of 2024, employees can take leave if a family member or household member was killed as a victim of a violent crime. Employees may use up to 2 work weeks, so 10 work days of unpaid leave, to attend the funeral, make arrangements, or grieve the death of a family or household member who was killed in a crime of violence. This leave must be completed within 60 days after the date the employee receives notice of the victim's death. Additionally, the employee cannot take leave that exceeds or is in addition to unpaid bereavement leave that may also be available under Illinois' Family Bereavement Leave Act. The amendment also outlines certification requirements for this expanded use of leave. Beginning August 1st of 2023, Louisiana requires most employers with 20 or more employees in Louisiana to provide a day of unpaid leave to employees for medically necessary genetic testing and preventative cancer screening. Private educational institutions, nonprofits, and religious organizations are exempt. Employees must be allowed to use any accrued paid time off, such as vacation time, during the leave. Employers can require that employees provide at least 15 days notice of their need for leave and make a reasonable effort to schedule the leave so that it doesn't disrupt business operations. Employers can also request documentation confirming that the testing or screening was performed, but can't ask for the test results. Employers need to post a notice about these rights in a conspicuous location at work. The state has been charged with creating a sample notice, which has not yet been released. Effective September 19th of 2023, the Maine Equal Pay Law is amended to prohibit pay discrimination based on race. The law applies to all employers in Maine with one or more employees. Under the law, employers may not discriminate between employees in the same establishment based on race by paying wages to any employee in any occupation in the state at a rate less than the rate at which the employer pays any employee of another race for comparable work on jobs that have comparable requirements relating to skill, effort, and responsibility. Differentials that are paid pursuant to established seniority systems or merit increase systems, or differences in the shift or time of day work that do not discriminate based on sex or race do not violate the law. Maine has also increased some of the exemptions to their pay frequency law as well as record keeping requirements. Maine employers have typically been required to pay employees in full at regular intervals that are not more than 16 days apart. Projected to take effect on September 19th of 2023, the amendments to the law make the following changes. It exempts members of the employer's family and salaried employees from the requirement that an employer pay in full at regular intervals all wages earned by the employee. It also removes the exemption for salary employees from the requirements relating to the rate of pay and records regarding time. In addition, it adds S corporations and limited liability partnerships to the exemptions from the requirements related to rate of pay and record keeping requirements. Effective January 1st of 2026, Maine will have a paid family and medical leave program. Employers must begin remitting premiums for it on January 1st of 2025, and benefits will be available as of May 1st of 2026, according to the governor's press release. Under the program, covered employees would be eligible for up to 12 weeks of paid leave to bond with their child during the first 12 months after the child's birth, adoption, or foster care placement, to care for their own or a family member's serious health condition, to attend a qualifying exigency, or to care for a family member who is a service member, to access safe leave because they or their family member was a victim of violence, assault, or sexual assault, or for any other reason under the Maine Family Medical Leave Law, including organ donation or a family member's death. The law does include definitions, eligibility terms, leave terms, notice requirements, and much more. The Maine Department of Labor will release more information as the implementation date gets closer. Effective August 1st of 2023, the Minnesota Human Rights Act, which applies to all employers in the state, is amended to prohibit discrimination on the basis of gender identity. Under the law, gender identity means a person's inherent sense of being a man, woman, both, or neither. The definition of sexual orientation is also amended to mean someone who is or is perceived of as being emotionally, physically, and sexually attracted to based on sex or gender identity. In addition, the human rights law was also amended to encompass in the definition of race traits that are typically associated with race, including but not limited to hair texture and hairstyles, such as braids, locks, and twists. Also effective August 1st, Minnesota establishes a worker safety requirement for warehouse distribution centers. The law applies to employers with 250 or more employees at one warehouse distribution center, or those that have a total of 1,000 or more employees at warehouse distribution centers in the state. Effective August 1st, Minnesota also legalized recreational marijuana. Individuals who are at least 21 years of age or older may use, possess, grow, and transport cannabis in specified locations and under certain circumstances. Employers are not required to permit or accommodate employee use, possession, or distribution of cannabis products while working or while at the workplace. Employers may also prohibit employees from being under the influence at work. However, an employer may not refuse to hire a job applicant or discipline or discharge an employee for using a lawful consumable product, including cannabis and cannabis products, away from the employer's premises during non-working hours. The law also significantly revises Minnesota's drug and alcohol testing in the Workplace Act to place limitations on cannabis testing for job applicants and employees. Effective September 17th, employers with 4 or more employees in New York are required to include a pay range and job description, if one exists, in advertisements for a job, promotion, or transfer opportunity that will either be physically performed at least partly in New York, or that would report to a supervisor, office, or other work site in New York. More information is available in a separate blog post on our website entitled "Show Me the Money: Getting Prepared for the New York Wage Disclosure Law." We have also hosted several webinars on the topic of compensation, with the most recent being "Show Me the Money: Preparing for New York's Wage Disclosure Law." Recorded versions of each webinar are available on the HR Works website. Under Oregon's Paid Family and Medical Leave Law, eligible employees may access paid family and medical leave benefits beginning on September 3rd of 2023. An employee's weekly benefit will depend on whether the employee's average weekly wage is equal to, greater than, or less than 65% of the state's average weekly wage. Paid leave benefits are available for periods of family care, to care for and bond with a newborn child, a newly adopted child, or a newly placed foster child, and to care for a covered family member with a serious health condition. Leave is also available for the employee's own serious health conditions and for reasons related to domestic violence. Employees may qualify for up to 12 weeks of paid family and medical leave per year, although an employee may take a total of up to 18 weeks of leave under certain circumstances. An employer may not discriminate against an employee who has taken leave or obtained benefits under the law. The benefit is funded through employer and employee contributions, which began on January 1st of this year. Additional information is available for employers on the Paid Leave Oregon website. Need more information on the content in this edition? HR Works is here to help. Current HR Works clients may contact the virtual helpline or their HR consultant for additional information on any of these legislative updates and next steps. Non-HR Works clients may contact us for HR solutions by calling us toll-free at 1-877-219-9062 or visiting our website. Before we close out this edition, we wanted to let you know that HR Works will also be hosting a free webinar on Wednesday, August 30th, entitled "What to Expect When Your Employee is Expecting." In this one-hour program, we will provide an overview of the legal requirements under federal law for managing pregnancy and pregnancy-related conditions in the workplace, and what employers' legal obligations are for making accommodations. SHRM and/or HRCI credits will be available for attendees of the live session. We hope that you can join us. And with that, we would like to thank you for watching this edition of the HR Focus.